Hello, I'm Terrell Hussein, and this is No Opinion. We're going to be going into the updates or the superseding indictment of United States versus Donald Trump, Walter Nada, and an additional defendant, Carlos de Oliveira. The original indictment had 37 counts. We're going to pick up with the new counts starting at count 38. Count 38. False statements and representations. The general allegations of the superseding indictment are realigned and fully incorporated here by reference. On or about June 3, 2022, in Palm Beach County, in the Southern District of Florida and elsewhere, the defendant, Donald J. Trump, in a matter within the jurisdiction of the judicial branch and the executive branch of the United States government, did knowingly and willingly make and cause to be made of materially false and fictitious and fraudulent statements and representations. That is, during a federal grand jury investigation and a federal criminal investigation being conducted by the FBI, Trump caused the following false statements and representations to be made to the grand jury and the FBI in a sworn certification executed by Trump Attorney 3. A diligent search was conducted of the boxes that were moved from the White House to Florida. B. The search was conducted after receipt of the subpoena in order to locate any and all documents that are responsive to the subpoena. And C. Any and all responsive documents accompany this certification. The statement's representation set forth above were false, as Trump knew, because Trump had directed the boxes be removed from the storage room before Trump Attorney 1 conducted the June 2, 2022 search for documents with classification markings so that Trump's Attorney 1 search would not and did not include all of Trump's boxes that were removed from the White House. Trump Attorney 1's search would not and did not locate all documents responsive to the May 11th subpoena. And all response documents were not provided to the FBI and the grand jury with the certification. In fact, after June 3, 2022, more than 100 documents with classification markings remained at the Mar-a-Lago club until the FBI search on August 8, 2022. All in violation of Title 18, United States Code, Section 1001. Count 39. False statements and representations. The general allegations of this superseding indictment are realigned and fully incorporated here by reference. On May 26, 2022, Nada participated in a voluntary interview with the FBI. During the interview, the FBI explained to Nada that the FBI was investigating how classified documents had been kept at the Mar-a-Lago club, and the FBI asked Nada questions about the location and movements of Trump's boxes before Trump provided 15 boxes to Nara on January 17, 2022. Nada was represented by counsel, and the FBI advised Nada that the interview was voluntary and that he could leave at any time. The FBI also advised Nada that it was a criminal offense to lie to the FBI. The interview was recorded. On or about May 26, 2022, in Palm Beach County, the Southern District of Florida, and elsewhere, the defendant, Walter Nada, in a matter within the jurisdiction of the executive branch of the United States government, did knowingly, willfully make a materially false, fictitious, and fraudulent statement and representation. That is, in a voluntary interview during a federal criminal investigation being conducted by the FBI, Nada was asked the following questions and gave the following false answers. Are you aware of any boxes being brought to his home, his suite? Answer, no. Question. All right. So to the best of your knowledge, you're saying that those boxes that you brought onto the truck, first time you ever laid eyes on them, was just the day of when Trump employee 2 needed you to. Answer, correct. Question, to take them, okay? Question, in knowing that we're trying to track the life of these boxes and where they could have been kept and stored and all that kind of stuff. Answer, Question, do you have any information that could help us understand, like, where they were kept? How were they kept? Were they secured? Were they locked? Something that makes the intelligence community feel better about these things, Answer, I wish I could tell you. I don't know. I don't. I honestly just don't know. Question, and what? So you only saw 15 boxes, 15, 17 boxes. Answer, Question, the day of the move, even they just showed up that day. Answer, they were in Pine Hall. Trump employee 2 just asked me, hey, can we move some boxes? Question, okay. Answer, and I was like, okay. Question, so you didn't know, had no idea they had got there before? Answer, no. The underscored statement and representations above were false, as Nada knew, because Nada did in fact know that the boxes in Pine Hall had been from the storage room, as Nada himself, with the assistance of Trump employee 2, had moved the boxes from the storage room to Pine Hall. And 2, Nada had observed the boxes in and moved them to various locations at the Mar-a-Lago Club, all in violation of Title 18, United States Code, Section 100. Count 40, altering, destroying, mutilating, or concealing an object. The general allegations of the superseding indictment are realigned and fully incorporated here by reference. From, on, or about June 22, 2022, through, in, or around August 22nd, in Palm Beach County, in the Southern District of Florida, and elsewhere, the defendants, Donald J. Trump, Joaquin Nada, and Carlos de Oliveira, did knowingly, corruptly persuade and attempt to persuade another person with intent to cause and induce any person to alter, destroy, mutilate, and conceal an object with intent to impair the object's integrity, availability for use in official proceedings. That is, Trump, Nada, and de Oliveira requested that Trump employee 4 delete any security camera footage at the Mar-a-Lago Club to prevent the footage from being provided to a federal grand jury, all in violation of Title 18, United States Code 1512. B. Count 41, corruptly altering, destroying, mutilating, or concealing a document, record, or other object. The general allegations of this superseding indictment are realigned and fully incorporated here by reference. From, on, or about June 22, 2022, through, in, or around August 2022, in Palm Beach County, in the Southern District of Florida, and elsewhere, the defendants, Donald J. Trump, Joaquin Nada, and Carlos de Oliveira, did corruptly alter, destroy, mutilate, and conceal a record, document, and other object, and attempted to do so with the intent to impair the object's integrity and availability for use in an official proceeding. That is, Trump, Nada, and de Oliveira requested that Trump employee 4 delete security camera footage at the Mar-a-Lago Club to prevent the footage from being provided to a federal grand jury, all in violation of Title 18, United States Code, Section 1512. Count 42, false statements and representations. The general allegations of the superseding indictment are realigned and fully incorporated here by reference. On January 13, 2023, de Oliveira participated in a voluntary interview with the FBI at de Oliveira's residence. During the interview, the FBI explained at De Oliveira that the FBI was investigating how classified documents had been kept at the Mar-a-Lago Club, and the FBI asked De Oliveira questions about the location and movements of Trump's boxes and other items. De Oliveira was advised by the FBI that the interviews was voluntary and that he could tell the agents to leave at any time. The FBI also advised De Oliveira that it was a criminal offense to lie to the FBI. The interview was recorded. On or about January 13, 2023, in Palm Beach County, the Southern District of Florida, and elsewhere, the defendant, Carlos De Oliveira, in a matter with the jurisdiction of the executive branch of the United States government, did knowingly and willingly make a materially false, fictitious, and fraudulent statement and representation. That is, in a voluntary interview during a federal criminal investigation being conducted by the FBI, De Oliveira was asked the following questions and gave the following false answers. Question: when, after the end of the presidency, boxes arrived to Mar-a-Lago, were you part of any group to help? Answer: no. Question: unload them and move them? Answer: no. Question: do you even know, or were you even there or aware that boxes were? Answer: no. Question: all this stuff was being moved in? Answer: never saw anything. Question: okay. Answer: yeah. And then question: even his personal stuff, like his clothes? Answer: never. Question: and furniture? Nothing? Answer: never saw nothing. Question: okay, so you don't know where items would have been stored as soon as he moved back to Mar-a-Lago? Answer: no. The underscored statements and representations above were false, and De Oliveira knew, because De Oliveira had personally observed and helped move Trump's boxes when they arrived at the Mar-a-Lago Club in January 2021. All in violation of Title 18, United States Code, Section 100. Jack Smith, Special Counsel. There you have it. All of the additional counts that have been added to the original indictment on the document case, United States versus Donald Trump. If you like this kind of content, I ask that you please like and subscribe, as we will continue to follow these cases as they develop. That said, thank you for watching. Have a great week.